this is for either Congressman Nadler or Congressman Franca. Under your definition of respect for marriage, should 3 men be able to marry each other, or should 1 man be able to marry 2 women?
No, our definition, you misinterpreted what we're saying. It's up to the states. What we are saying here is not that we are setting a federal definition of marriage. You seem to miss the point. What we're saying is the Equal Protection Clause, this is a very specific point we're making here, and in DOMA, that the state should decide what it is, and that we are saying the federal government should respect what the states do.
So they could do that under this change in law, the states.
Whatever powers states have to marry are unaffected by this bill. That's up to the states. We are talking here about whether or not, once a state has made a decision to do it. Now, no state has allowed polygamy. As a matter of fact, the federal government would not allow Utah to become a state until there was a clarity on that. But you misread this if you think this bill says anybody, that this sets who gets married to whom. What this bill does is repeal a federal statute that says the federal government will not recognize same-sex marriages. That's all it does. It does not otherwise affect the ability of states to decide who marries whom.
Let me just add to that. Historically, until DOMA was enacted in 1996, the federal government never defined marriage, never said who could get married, who couldn't, who they would recognize. The federal government passed many laws that apply to married couples. A married couple doesn't pay inheritance tax from one to the other. A married couple can have survivorship and Social Security. A married couple can file joint income taxes and so forth. But in all those laws, it simply says a married couple. It doesn't purport to say who a married couple is. And if anybody ever asked that question, the answer was, what does the state say? The states define marriage. That's historically the case. They always have. And the laws differ from one state to another. In one state, first cousins can marry. In another state, they can't. The minimum age for marriage differs from state to state. So the states have always determined that until DOMA. DOMA says that for federal purposes, we're not going to recognize a marriage that the state of Massachusetts or the state of whatever decides is a valid marriage. What this bill does is simply repeals that and says, in effect, we're going to go back to the status quo ante, and that if Massachusetts thinks you're married, if you get married legally in any state, federal government follows suit. And the questions you're asking, who can get married, etc., it's all a state matter, and it's totally unaffected by this legislation. And it always was a state matter, and we're just going back to the ancient.
One other point as to the lawsuits. The lawsuits specifically address discrimination based on sexual orientation. There are other questions that other lines that might be drawn. Most states do. The states have laws about consanguinity. One relative can marry other relative, unaffected by this. So this says, the lawsuits say, you cannot discriminate based on sexual orientation. You can have whatever rules you want for marriage, but they cannot discriminate based on sexual orientation. Secondly, whatever the states do decide, the federal government will treat equally. So it has nothing to do with the broader definition of marriage.